Welcome to the House of Representatives Committee on Judiciary and Hawaiian Affairs. It is 2 p.m. Tuesday, March 14th. Here we are in conference room 325. Welcome. Thanks to everyone for being here in person and on Zoom land. We are here for the purposes of hearing numerous measures, and I'm grateful to have with me my Vice Chair, Greg Takayama, and Member Representative Kanani Souza. Other members will join us as soon as they can. For those who are testifying, I would request that you keep your testimony to about 2 minutes, and at that point I'll ask you to summarize, and I appreciate your kokua. If you're testifying via remote means, please keep yourself muted and your video off while waiting to testify, and then after your testimony is complete as well. If you have some technical issues and you're on Zoom, use the chat function. You can chat with the technical staff and they can help you out. Only use that for technical issues. If you're disconnected unexpectedly, don't panic. Just rejoin when you can, and we'll do our best to fit you in and so you can provide testimony when you return. If the power goes out here and we have to reschedule, we'll make sure to post the notice as required so you'll know what the plan is. If you're testifying on Zoom, please do not use any trademarked or copyrighted images for a background, because that means when we get posted on YouTube, they bump us off because we don't have the copyright to use those images. So please help us out by not using trademarked or copyrighted images. And as always, please refrain from any profanity or uncivil behavior, or else I'll ask you to be better mannered, and if you aren't nice, then we'll ask you to leave. But that's never happened, so I don't think it will. And please just, everyone, we can disagree, but let's not be disagreeable. We're working on things to improve matters for the people of Hawaii and the environment of Hawaii, and I think we're all allies in that regard. Okay, with those prefatory remarks, let's go ahead and get started on our hearing. First up, we have Senate Bill 1616, relating to Hawaiian as an official language of the state of Hawaii. It requires that the Hawaiian version of a law be held binding if the law in question was originally drafted in Hawaiian and then translated into English. First up, we have testimony in opposition from the Attorney General. In person. Thank you for being here, sir. The floor is yours. Please proceed.
Good afternoon, Chair, members of the committee. Deputy Attorney General Ryan Kanakaole for the Department of the Attorney General. We oppose this bill in its current form. We've submitted written testimony with our amendments, our suggested amendments. The bill does create some concerns for us. It would, as currently written, we believe that it would create some ambiguities in the application and interpretation of laws of concern. Laws that were originally drafted in Hawaiian may subsequently be amended over time in English. And the effect of this bill as written on such laws would be unclear. It may very well result in a patchwork of binding language in both English and Hawaiian within the same law. To mitigate these ambiguities, we provided our amendments, our suggested amendments to page 3, lines 2 to 5, to define the bill's application to laws originally drafted in Hawaiian that have not been later amended, codified, recodified, or reenacted in English. Thank you for the opportunity to testify. I'm here to answer any questions.
Thank you very much, Mr. Kanakaole, and thank you for the amendments. I appreciate your suggested amendments. Okay, next we have testimony and support from the Department of Land and Natural Resources. Welcome. The floor is yours. Please proceed.
Aloha. Pua Ayu for the Department of Land and Natural Resources. The department stands on its testimony and support.
If I could ask you to summarize your main points of your testimony, that way everyone who's watching could understand.
Our testimony was very brief. It just basically stated the purpose and that we supported the purpose.
Okay, thank you very much. Next we have testimony and support from Zuri Aki, Office of Hawaiian Affairs. Next, we have testimony in opposition from Kenneth Conklin, Center for Hawaiian Sovereignty Studies. Next, testimony and support from Johanna Choktam. Welcome. The floor is yours. Please proceed.
Aloha, Chair Tarnas, Vice Chair Takayama, and I am Johanna Chok-Tam. I am the Olala Hawaii Coordinator for the Judiciary. And we do stand in support of the law. We appreciate that it forces us or calls to us to look at the original law in its original language, whether it be Hawaiian or English, to determine the intent of the law. It also reinforces our Olala Hawaii's status as an official language, and saying that laws drafted in Hawaiian can stand alongside those that are written in English. There is going to be some difficulty, though, in identifying the laws, the applicability of this change to our laws, because we do have kingdom law that does apply, or we have HRS laws that look back to our kingdom laws. And there will be some extra research, but we don't think that's unattainable or unresearchable. So yes, mahalo for the opportunity to testify.
Certainly, mahalo. And next we have testimony and support from Leimomi Khan and testimony and support from Dana Keawe. Is there anyone else here wishing to testify on Senate Bill 16, Senate Bill 16? If not, questions, members? Real brief question for DLNR, if I may. In your testimony, you have said that laws written in Hawaiian and translated into English may have lost some of their meaning. The way this is set up, just so you know, the Attorney General has suggested that the English version, provided that if the law in question was originally drafted in Hawaiian and the English version was translated based on the Hawaiian version, and if the law has not been subsequently amended, codified, recodified, or reenacted in English, the Hawaiian version shall be binding. I'm just curious, have you actually found any, give me an example of where the Hawaiian version of the law had more meaning than the English translation, and give me an example of that.
So I'm sorry, I did not do that research.
Okay, so it
But
wasn't something that came to mind.
It came to mind because the Maori example is like that. And so they've actually done this, right? They went back to their codified laws that were in Maori, and they said, okay, the Maori's going to stand. So when they looked at their Treaty of Waitangi, the Maori and the translation into English didn't always match, right? And so that changed a lot of their laws when they went that way. So that's where I got it from.
Got it. Okay, so there wasn't anything in particular that came to mind
Not
about
for
Hawaii
Hawaii.
law
No.
that you had as an example that brought this concern?
No,
Okay, all right.
thank you.
Yes, Deputy Director, did you want to add to that?
Sure.
If you could introduce yourself for those who are listening.
Sure, thank you. Laura Ka'akua, Deputy Director for DLNR, and I agree with Ms. Ayu's in our thought process there. And I think there's so many words in Olala Hawaii that describe our natural, cultural, and historic resources that the department is responsible for protecting. So I think that was on our mind as well. In our position to support this bill, like just look at the word aina, right? And in that little tiny word that's 4-5 letters with the okina, the meaning of aina is so great, right? That I to eat, to feed, and na, that which, so that which nourishes us. And so in this little tiny word, there's this whole concept of reciprocity with land being that which feeds us. And so that concept of our relationship with land being cyclical is wrapped up in this little tiny word. And so it takes oftentimes paragraphs to translate in the sort of holistic nature of our Hawaiian words. And so I think that was our thought as well, that the lens that you have to look at the world with when you are speaking in Olala Hawaii is different from the lens that we look with when we speak in English.
Makes
Mahalo.
sense. Yeah, mahalo. Appreciate that. And I look forward to learning from the department going forward when you find those instances and help us at the legislature understand that. Because that's a nuance and a depth that often we don't understand unless you educate us. So look forward to that. Okay, very good. Thank you very much. Any other questions, members? If not, we'll move on. Thank you very much to the testifiers. Next, we have Senate Bill 5757, relating to the judiciary's Olelo Hawaii initiatives. It appropriates funds to the judiciary to support the Olelo Hawaii initiatives. First up, we have testimony and support from Johanna Chaktam with the judiciary. Welcome. Please proceed.
Aloha kako. I just wanted to say that we support this bill wholeheartedly. However, we're respectfully asking that the appropriation amount and effective date be reinstated. We were originally allocated in this bill $100,000 for the program director and $200,000 for the program for each of the following 2 fiscal years. Because the program director position was made permanent, the $100,000 for the program director was not needed. So with Senate Draft 1, they moved the $100K from the program director position to the program, resulting in a $300,000 fund for each year for the program. Senate Draft 2 removed the funds and also the effective date. So we're asking that the funds be reinstated as well as the effective date.
And specifically, the funds being the $200,000 per year
Yes, yes.
for the 2 fiscal years. And that's what you're asking to be reinstated?
Correct.
Okay, thank you.
Thank you. Mahalo.
Mahalo. Next, we have testimony and support from the Office of Hawaiian Affairs. Testimony in opposition from Dr. Kenneth Conklin, Center for Hawaiian Sovereignty Studies. Testimony and support from Leimomi Khan, and testimony and support from Dana Keawe. Is there anyone else here wishing to testify on Senate Bill 57? If not, questions, members? Seeing none, thank you very much to the testifiers. We'll move on. Senate Bill 261, relating to the Hawaiian Homes Commission Act, requires the Department of Hawaiian Homelands to provide to beneficiaries of the Hawaiian Homes Commission Act 1920 monthly accountability reports that contain certain information on leases and fiscal matters. First up, we have testimony in opposition from the Department of Hawaiian Homelands. Welcome. Thanks very much for being here. The floor is yours. Please proceed.
Thank you. Good afternoon, Chair, Vice Chair, and members of the committee. We are in opposition.
And you are?
And I'm sorry, I'm Katie Ducat, Deputy Director of the
Deputy
DHA.
Director. It's a pleasure to have you here.
Thank you. In sum, the opposition really is a matter of resources, in particular man hours it would take in addition to produce these monthly accountability reports, with the point of our testimony being that we already aggregate this kind of data, and it is publicly available. It is actually introduced monthly to the commission, and the reason why we do that actually is because certain types of transactions, for example, a consent to a mortgage, actually requires the approval of the commission. So we actually do have a method in which to have this information available to the public. And that is basically, in sum, why we would oppose, or why we are opposing the bill in this form. Thank you.
Thank you very much. And for those who are listening, you were saying specifically known as the consent agenda. In your monthly agendas is where one might find such information.
That's correct, yes.
Thank you very much. Appreciate that. Okay, next we have testimony and support from Dana Keawe. Is there anyone else here wishing to testify on Senate Bill 261? If not, questions, members? Seeing none, we'll move on. Thank you very much. Next, Senate Bill 490, relating to compliance on Hawaiian homelands. It appropriates funds to the Department of Law Enforcement to hire law enforcement officers dedicated to investigating complaints, conducting investigations, and cooperating with enforcement authorities to ensure compliance with state laws and rules, county ordinances, including the Hawaiian Homes Commission Act 1920 as amended, and the rules adopted thereunder on Hawaiian homelands, provided that the law enforcement officers hired for this purpose shall not be prohibited from exercising their law enforcement authority outside of the Hawaiian homelands. First up, we have testimony with comments from the Department of Hawaiian Homelands. Please proceed.
Good afternoon again, Katie Ducat for DHHL. We do offer, actually we're in support of this bill. We do have a preference for the way that the language is originally, which would have created our own compliance unit within the department. But to the extent that this bill would provide funding and personnel with an emphasis towards compliance on DHHL lands with the cooperation or within the Department of Law Enforcement, we actually are in support of this bill.
Thank you very much. Next, we have testimony in opposition from Regina Gregory, testimony in support from Thomas Haya, testimony in support from Marianne Capuni. Is there anyone else here wishing to testify in Senate Bill 490? If not, questions, members? I have a quick question for the Department of Hawaiian Homelands. Some members have approached me and said, why don't the police do their job and enforce laws on Hawaiian Homelands? Could you help us understand that?
Sure. When it comes to the Department of Hawaiian Homelands, what the beneficiaries experience is that there's a lot of confusion with, for whatever reason, county police departments from island to island not understanding or treating Department of Hawaiian Homelands as if it's separate or different, and thinking that they cannot enforce the state, criminal laws of the state of Hawaii upon Department of Hawaiian Homelands. Now, there is no such prohibition. There's actually case law, it's State versus Jim, that says that criminal laws do apply to DHHL. Nonetheless, police departments, and it's, across the individual counties, we have run into issues where they kind of take this hands-off or we don't know approach. And so we are a state agency, and DHHL lands are state lands, so it actually does make sense to have, a state law enforcement agency be kind of the force that comes and helps us when we do need help, although that doesn't prevent the individual police departments from going in on a 911 call when necessary.
Okay, and could I ask the same question about state law enforcement officers? Do you have a similar difficulty in getting them to come on to Hawaiian Homelands to enforce state laws, like sheriffs or
We do. It takes
Division
a lot of
Conservation Resource Enforcement?
It takes a lot of coordination is what it is. So an immediate response to a situation that's happening on the homelands, very difficult. If something is planned in advance, we can get the cooperation of the police department with the sheriffs, et cetera. But the concern is often things happen on the lands and our beneficiaries need a response immediately, and that is what the concern is.
So
Yeah.
if it's an immediate issue, it's an emergency, so your beneficiaries would dial 911, or
That's
sorry, you
correct.
don't dial it anymore. You were to call 911. And you're going to get the police and fire. And you're saying that in some counties, you just don't get a response?
You might get a response, but and of course this is anecdotal, but we do hear from beneficiaries that the police won't do anything. They're hesitant to do anything other than a report. There's a lack of follow-up. So those kinds of issues.
Okay, and one last question, if I may. Have you engaged in any direct discussions with the county police departments to identify what the misunderstanding is and then seek to correct that misunderstanding so that the police would actually do their job? Because it sounds like it's really based on ignorance of what the law is.
Yes, in fact, I am only aware of one. We actually have a memorandum of understanding with County of Hawaii, right? County of Hawaii, and that's, and that helps to establish a stronger relationship and understanding of, Hawaii County PD enforcing on the Hawaiian Homelands, but I don't believe we have MOUs with any of the other counties.
But it's helping in Hawaii County?
I actually
Not
can't.
sure.
Yeah, I'm not sure. about
Okay,
that.
okay. Well, that's very helpful to know. Thank you very
Thank
much.
you.
Any other questions, members? If not, we'll move on. Thank you very much. Next, we have Senate Bill 738, relating to the Department of Hawaiian Homelands. It authorizes Department of Hawaiian Homelands to administer a lease award program for beneficiaries on the homestead lease waiting list who are 60 years old or older or terminally ill under certain conditions. Authorizes qualified successors of beneficiaries on the waiting list who died before receiving a lease to file a claim for a lease award within 4 years of the effective date. Department of Hawaiian Homelands has to adopt rules by a certain date as well. Okay, first up, Senate Bill 738, we have the Department of Hawaiian Homelands with comments.
Good afternoon, Katie Ducat again for DHHL. We do have comments. We just want to, while we appreciate the intent of the bill, we do have concerns because historically the waiting list has operated on a chronological basis based on an applicant's application date. And so this would create a situation where persons who are either by age or by a condition would be given an award ahead of those who perhaps have been on the list longer. And so that's really the primary comment that we would make, and that when it comes to the wait list and understanding that according to the Hawaiian Homes Commission Act, Section 207A, new awards, an initial award has to be made to a native Hawaiian, so a small and native Hawaiian, those who are of at least 50% blood quantum under the law. So I have seen testimony, and there is a concern because when you use the term qualified successor, when it comes to somebody holding a lease, a qualified successor can actually be a spouse, a child, a grandchild, or a sibling who is less than 50%. That's in the case of somebody who already has a lease. So when we're talking about applicants, though, those who have not had a lease and they want to transfer their application to another successor, the successor does have to be native Hawaiian in order to take a new lease award, and that's the way that the commission, the Hawaiian Homes Commission Act operates. So that's really the meat of our comments with regard to this bill.
Thank you very much.
You're welcome.
Next, we have testimony in support from Melody Aduha. Testimony in support from Zeb Jones. Testimony in support from Kapua Keli'ikoa Kamai. Testimony in support from Renette Fukui. Please proceed. Renette Fukui.
I'm on Zoom.
Yes, please proceed.
Okay. My name is Renette Fukui. I'm providing this testimony via live stream to support SB 738 and any amendments. I currently live in Hilo, but I was born and raised in North Kohala. My mother, Marianne Capuni, passed away while on the Hawaiian home wait list for almost 20 years. I could not be her successor because on the wait list, you have to be 50% Hawaiian. If no one comes, my mother's name is on the public notice dated November 20th, 2022 for 180 days. So if no one comes forward to claim my mother's position on the Hawaiian home listing, her name will be removed from the list. All these years she waited for Hawaiian Homeland, and now to have her name just removed is demoralizing. My request is to take my mother's place on the Hawaiian home wait list. The law was changed in 1986 by lowering the blood quantum requirement to 25% for spouse and children, effective 1997 for grandchildren and 2005 for brothers and sisters. My question is, why is there a separate set of successor laws for beneficiaries who have been awarded a lease and a second set of successor laws for beneficiaries that have passed while on the waiting list? There is no difference. You know, when they lowered the blood quantum in 1986, 1997, and 2005, they should have changed the requirements for both categories of successorship. I do not believe that the current process is a fair process. The law needs to be changed to address these successor discrepancies. Unfortunately, the Department of Hawaiian Homelands does not support this measure. Instead of finding solutions to support Native Hawaiians to acquire Hawaiian Homeland leases, they are finding roadblocks. What will happen if we continue with this DHHL status quo is that the state will have a new set of plaintiffs, as in Kalima versus the state. Mahalo to everyone for allowing me to participate and provide my sincere concerns in this live testimony.
Mahalo, Ms.
Thank
Fukui. Thank you very much for testifying. Next, we have testimony in support from Kaimo Mulstein. Testimony in support from Diane Napua Reyes McHugh. Testimony in support from Albert Reyes. Testimony in opposition from Patrick Kaha Vaiola'a. Testimony in support from Nancy Jones, Dana Keave, Marianne Capuni, Robert Ayu, Lena Suzuki, and Nani Peterson. Is there anyone else wishing to testify on Senate Bill 738? If not, questions, members? I have one question for the Department of Hawaiian Homelands, if I may. One of the testifiers, who happens to be kupuna in my district, Mrs. Capuni, said that we've got to submit this to the Department of Interior to determine the necessity of congressional approval. Is that accurate?
The way that this bill is drafted is that it is not a direct amendment to the Hawaiian Homes Commission Act. So the short answer is, sorry, it's not going to be a short answer. It's going to be a long one. So the waiting list is not actually in the Hawaiian Homes Commission Act. So what the Hawaiian Homes Commission Act has is a provision, I believe it's section 222, that basically says for the effective administration of this act, the department shall promulgate rules pursuant to Chapter 91, just like any other state agency, right? And so that's actually where we find our waiting list rules. It's actually in our administrative rules. It's not actually within the Hawaiian Homes Commission Act. So to the extent that this bill is asking us to basically create a program by modifying our rules, it doesn't require the consent of Congress unless we run afoul of the framework of the Hawaiian Homes Commission Act, right? Which we wouldn't be able to do anyway, right? The rules cannot go beyond what the Hawaiian Homes Commission Act allows, right? And and that's why our comments caution, right? As the act currently stands, and as the testifier actually pointed out, people on the waiting list, in order to pass on their applicant to a successor, that successor has to be 50%, whereas someone who has a lease can actually pass that lease on to certain classes of relative who are less than 50, but at least 25%. And so if the rules do something that allows a wait list successor in the contemplation of this to be less than 50, then, you know, we would expect DOI to step in because they would have something to say about that. They absolutely have the authority whenever an amendment to the act, or in this case, a state law, would affect the lowering of the blood quantum.
Okay.
Yeah.
So in that case, then it would be appropriate to seek the concurrence of the Department of Interior.
Yeah, and I believe that the bill has, I believe it's, actually no, this bill doesn't have the usual language that you would find. There's usually a clause that states, you know, it's because again, this isn't a direct amendment to the Hawaiian Homes Commission Act. I don't think anybody thought that it needed the specific language that says this law shall be subject or might be subject to the consent of Congress and needs to do that. But yeah, that's kind of where you would want to put the language.
Okay, thank you very much. Okay, any other questions, members? If not, we'll move on. Thanks very much to the testifiers. Next bill, Senate Bill 739, relating to desecration, reduces the requisite state of mind for the criminal offense of desecration from, quote, intentionally to, quote, knowingly. And it simplifies the definition of the word desecrate. On Senate Bill 739, we have first up testimony with comments from the Office of the Public Defender. Welcome.
Thank you. Good afternoon.
The floor is yours. Please proceed.
Excuse me. Good afternoon, Chair Tarnas, Vice Chair Takayama, members of the committee. My name is Lee Higher Carm, the Chief Deputy of the Office of the Public Defender. The Office of the Public Defender just weighs in on this just to add comment and with the suggestion that rather than striking intentionally, you simply add the word or knowingly, which will work just fine. And we make this suggestion only because it is sound language and it would also be consistent with most of the rest of the Hawaii Penal Code.
Thank you very much.
Thank you for the opportunity.
Yes, thank you very much. And in your testimony, you give several examples. HRS 708-821 uses intentionally or knowingly. 708-822 does the same. 708-823 does the same. So that's giving examples of your recommendation why make it consistent.
Right, and the desecration statute in its commentary references criminal property damage, so we thought we'd run with that.
That was appropriate. Yeah, okay. Thank you very much.
Thank you.
Okay, next we have testimony and support from the Council for Native Hawaiian Advancement. Testimony and support from Kevin Chang, Kua Aina Ulu Au Amo. Testimony and support from Dana Keawe and Jean Ross Davis, Rosie Davis, Faith Tui Purutu. Anyone else wishing to testify on Senate Bill 739? If not, questions, members? Sterling Wong, Council for Native Hawaiian Advancement. Please proceed.
Aloha Chair, Vice Chair, members of the committee, Sterling Wong for CNHA. We stand on our written testimony in support. Mahalo for the opportunity to testify. We welcome any comments or questions we can answer. Mahalo.
Thank you, Sterling. But since you're here, I thought, if you could summarize your main point in your testimony. You say you support this. If you could just briefly describe why.
Yeah, mahalo for that, Chair. I think sacred sites, cultural sites, they tend to be easily accessible on public lands oftentimes. And so this bill would give law enforcement additional tools to make sure our cultural sites are protected.
Thank you. All right, thank you very much.
Mahalo nui.
Pleasure to see you again, sir. Any other testifiers on this measure, Senate Bill 739? If not, questions, members? One quick question to Mr. Wong. Sterling, you heard the Office of the Public Defender just suggesting we use the words, we keep them both, so we say intentionally or knowingly. Is that something that you would agree to?
Yeah, we would defer. Thank you for that question, Mr. Chairman. We would defer to the Public Defender's Office. What they propose as an amendment sounds reasonable.
Great, thank you very much. Any other questions, members? If not, we'll move on. Thank you to all the testifiers. Next, we have Senate Bill 741 relating to the Hawaiian Homes Commission Act. It excludes from any waiting list maintained by the Department of Hawaiian Homelands any lessee or successor who sells or transfers their lease on a tract of Hawaiian Homelands for personal gain. It establishes that the Hawaiian Homes Commission shall have a right of first refusal for the sale or transfer of a lessee's interest in the lease when the sale or transfer is for personal gain. First up on Senate Bill 741, we have the Department of Hawaiian Homelands with comments.
Good afternoon again, Katie Ducat for the Department of Hawaiian Homelands. In sum, what our comments basically is that when we did a study, the amount of transactions that would be affected was a very small one. And so the department's position was that as a result, this legislation might have unintended consequences and impacts to those who perhaps are not going to benefit from financial gain, but are benefit from a lease transfer just because they happen to be related to certain people who, over time they get one lease and then another and then another. Of note, though, this is, despite the small number of transactions that, this might, that actually happen, the commission nonetheless, the Hawaiian Homes Commission nonetheless, does recognize it as a problem, and they are concerned about it as well. So we just want to raise that the commission, separate from this legislation, is intending to form a permitted interaction group to further investigate this kind of transaction and to try to come up with a solution, probably via, or it would have to be via, an amendment to the rules or perhaps a creation to to a new rule that would try to address all of those kinds and think through what would be the unintended consequences. What are we really trying to stop here? And then be clear about that. So we did want to raise that. It is a new development, and that's in our testimony. So we did want to raise that as part of our comments here, that perhaps the better way is to let the commission work through these issues, because they're really the authority on the ground when it comes to these things, as opposed to have this done through legislation.
Thank you. And so just to be clear, your testimony requests that this measure be deferred to allow the Hawaiian Homes Commission the opportunity to consider this issue before any legislative action.
That's correct, yes.
Okay, great. Thank you very much for that clarification. Next, we have testimony in support from Kenneth Conklin, Center for Hawaiian Sovereignty Studies. Testimony in support from Regina Gregory, Dana Keave, Rosie Davis, and Faith Tui Polotu. Is there anyone else wishing to testify on Senate Bill 741? Yes, please, come on up. Please introduce yourself, and the floor is yours. Take your time.
Aloha, Chair.
Aloha.
Vice Chair, and members of the committee. First of all, I'd like to say I am a disabled kupuna. I'm also a waitlister. I am supportive of Bill 741 because I know personally people have sold their lease that came from the very entity that we established. We are celebrating Punsko Hills, the Act, 100 years. This has been going on for decades, where leases have been given out. People have got back on the list. It's not, at that point, it wasn't what you knew, it's who knew you. And people got leases. I've been through so many governors. I've come and talked to senators. It goes in one ear and out the other. I am almost 70 years old. This July I'll be 70. I've been waiting for Hawaiian Homes for 47 years. I know people who've been on the wait list for maybe 20 years, and they got leases. Where is my lease? I'm a plaintiff of the Kalima case. Now, I want to know, money is one thing, but where is the land? It sits in the Department of Hawaiian Homelands. They don't have no respect for the elders, and this is what we're giving up, respect. People have to respect their elders because the kupunas know more than any law. We have lived here. This is my motherland. I have children moving to the mainland, which I go back and forth. Why? Because they said, Mom, we're outpriced in paradise. We have to move to the mainland so we can get ahead. They bought their homes up there. They can't buy it here. They have good jobs up there. They can't find good jobs down here. I have one more daughter here. That's why I go back and forth. But you are forcing the locals to move because nothing is done. Now, we, Hawaiian Homes, these entities that we have, yes, the state and the federal government, they take the land. They're on part of the land. We are landlords. Why aren't we given the same right? Give us our payment, what we need, so we can run Department of Hawaiian Homes. I will not take up more time, but I want you folks to understand how severe this is. We're running circles. Let's come up with solutions. I've heard it over and over. I'm tired of hearing it. It's time we sit down and do something about it. Instead of talking, let's do something about it. Mahalo for your time.
Mahalo. And if I could ask Keone to follow up with her and get her name so that we could have it for our record. Thank you very much.
You're welcome.
Mahalo. Is there anyone else here wishing to testify on this measure? If not, questions? Yes, please. Kanani
Or
Souza,
Katie,
Representative
please.
Souza.
Thank you for expressing your concerns about this bill. I just wanted to know if you could explain what the right of first refusal actually looks like in the context of this bill. Is it where Hawaiian Homes will essentially buy back the property or take back the lease and pay fair market value, or how does that work?
As I understand it, yes. So if there is a property that is put up for sale to profit, and I guess there's a certain indication that this really is like a sale for profit, this is an arm's length transaction, these are not relatives, somebody is standing to gain here. I believe the right of first refusal that's in this bill would act as DHHL being able to actually purchase the property first, is my understanding of the intent. I believe that was included maybe out of the Hawaiian committee. I don't think that was originally in here. I think that was, but I believe that's the intent when it was inserted.
Yeah, my problem is that I think that in trying to resolve the situation that perhaps has been caused by a few bad actors, which is what you've kind of mentioned, the whole class of basically Hawaiian Homes lessees is going to be affected because they can't essentially sell in the way that they want. Their hands are tied. So just another question, Chair, if I may. So kind of going to Auntie's point, if she's been on the list for 47 years, she claims. And so how does it work where, I know that I heard one example coming out of the Senate committee where somebody went back on the list like 5 times, right? How does that work when people are claiming that they've been on the list for so many years, but then you have people who are able, even if it's a small number, to kind of abuse the process? How are they able to do that if the wait list is so long and arduous and people can't get homes? Because I've heard many different perspectives where some people have been on the list for a short time, and then some people have been on the list for 47 years, never got called. So how does this work, and how is somebody able to abuse the process if the wait period is so long?
I will do my best to answer that.
I know maybe it's you guys.
So one of because there's several issues. One of the ways it happens is that someone who's interested in selling their leasehold does not have to sell to the next person on the wait list. In fact, they just need to find a qualified native Hawaiian to buy. And so in that case, the wait list isn't affected, right? It's just, so long as they meet the blood quantum threshold, a home could be sold/transferred in that way. And so that doesn't affect the wait list. And the seller then goes not to the top, but they can then reapply and they would be put back on the list. So there's nothing right now, there's no mechanism that I'm aware of that kind of makes that stopper, right? That prevents somebody from coming back onto the wait list. So that's one issue. Another issue might be that despite making an offer to the oldest applicant on the wait list, that perhaps whatever, that if you're selling it on market price, even market prices, which are different for Hawaiian Homelands versus what you would have to pay fee simple, that if you go down the wait list, perhaps there's going to be a lot of people who won't be able to financially qualify. And so, and this isn't really in the context of transfers, right? This is when we're trying to, say, re-award a lot. It's come back into our inventory, now we want to find a new re-award. So the way that it functions is that, depending on the area, the appropriate wait list is pulled up, and our contracts and awards division offers, and they do it, right? They go down the wait list, and sometimes you're not going to get the oldest or even the second oldest applicant. It kind of goes down maybe even midway to someone who is then financially qualified, and it's the beneficiaries who have the economic means, right, and who are about the system, who can kind of do this
Right.
over and over again.
Sorry, I'm going to
Yeah.
cut you off. I guess I understand what you're saying but it just seems like these people have not been called at all to even qualify or to even have the opportunity to qualify. Because I understand what you're saying, right? You have to be in the position to buy. So they will bypass people if you're not qualified and able to submit a pre-approval letter. One more question, Chair, if I may.
Yes.
Okay. So the other question I have is that what happens to people who actually bought their home, say 10 years ago, say they bought, out in my district, the, Kaupe'a area, or Malu'ohai, and now they want to sell, so they will be binded by this if this becomes law, correct? Where they have to go through the process of right of first refusal. It's not something, it's essentially retroactive to anybody who has bought Hawaiian homes, correct? Or is this just for people going forward? Because it doesn't seem that way.
Yeah, usually when a law takes effect, it's not retroactive unless specifically stated to be retroactive in the law. So this would be only prospective going forward.
Well, I guess what the question is people have already bought, but they haven't sold. So I think that
okay.
in this regards, it definitely will probably apply.
Yeah, so if, back in 10 years ago, this wasn't a factor in your purchasing.
Exactly.
Yeah, and so this going
Because
forward.
maybe some people would not have bought. I mean, not everybody,
Yeah.
is buying because they absolutely need a house, as you know. That's perhaps where a lot of this abuse might come from. So maybe they would not have purchased if they had known that there would be this sort of buyback restriction or with the lease, the leases. But okay, thank you, Chair.
Certainly. Thank you for
And
those.
thank you, Katie.
Yeah, thanks for those questions. Thank you very much for the responses. Any other questions, members? If not, we'll go on. Thanks very much for your testimony. Thanks to everyone for their testimony. Mahalo. Next, we have Senate Bill 1014 relating to independent legal counsel. This measure allows the Department of Hawaiian Homelands to retain independent legal counsel where the opposing party to the reasonably anticipated litigation is the state or another state agency. Provides that fees owed to independent legal counsel shall be paid by the state. First up, we have testimony in opposition from the Attorney General.
Good afternoon again, Chair, Vice Chair, members of the committee. Ryan Kanakaole, Deputy Attorney General, testifying on behalf of the Department of the Attorney General. The Department of the Attorney General opposes this bill and requests it be held in committee. Our opposition to the bill is provided in our written testimony. We believe that the Department of the Attorney General is best equipped, best positioned to handle a broad array of legal issues that DHHL encounters, because we can not only draw from the experience and expertise of the deputies specifically assigned to the Department of Hawaiian Homelands, but the many other deputies in our department as well. In certain areas of law, particularly those that regulate public agencies, such as procurement, sunshine law, Uniform Information Practices Act, private attorneys would have little to no expertise in those areas, and it would be difficult, not to mention expensive, to duplicate the work that our office provides. Moreover, our department is uniquely situated under the law where we can undertake concurrent representation of several state agencies or individuals where there are conflicts of interest. Private attorneys are prohibited from doing that. In fact, in the past, we have represented the Department of Hawaiian Homelands against other state agencies, such as the Department of Land and Natural Resources, and we will continue to do so. Finally, there is a process in place through which the Department of Hawaiian Homelands can retain private attorneys. DHHL will submit a request to our office, and the request is reviewed by committee and the Attorney General, and with her recommendation and the Governor's approval, DHHL can go and retain that private attorney. DHHL has gone through this process before without incident. For these reasons, we believe the changes in the law that the bill proposes is unnecessary and stand in opposition to it. Thank you for my opportunity to testify. I'm here to answer any questions.
Thank you very much. Next, we have testimony and support from the Department of Hawaiian Homelands.
Good afternoon, Katie Ducat for the Department of Hawaiian Homelands, and we are in strong support of this bill. In some, we'll acknowledge that there is a mechanism by which DHHL could have independent counsel, but it does have to go through the Attorney General's. And so what the department would like is to be able to, on its own, recognize when there might be a conflict, especially one where DHHL is going to be in direct opposition, and we know that they're going to be in direct opposition with another state agency, to go ahead and do that for itself, and to have the cost of doing so be borne by the state of Hawaii.
Thank you very much. Next, we have testimony in support from Marianne Capuni and from Regina Nani Peterson. Is there anyone else wishing to testify on Senate Bill 1014? If not, questions, members? Representative Ganadin.
To the department. Okay.
Bring that mic right up.
Every time. Good afternoon.
Good afternoon.
In the instances where the department is conflicted with the state and there's prospective litigation, how does that process, how do you go about finding counsel, retaining counsel, and what is the cost?
From the department, we actually generate a request. I think this might actually be how does the whole process go? So from the department, we would initiate a request to the Department of the Attorney General. The Attorney General then has its process as to evaluating whether or not independent counsel or outside counsel is appropriate, and then gives a waiver. Does that answer your question, or is that the answer that you were?
Well, yeah, you started to outline the process.
Yeah.
In your mind, you practice law. Does this suffice to provide, this current process suffice to provide the department with independent counsel in these proceedings?
So I will say that I know of 2 examples that I can name for you where this process as it currently operates works, right? So one, of course, is the Nelson case. So DHHL, of course, got its own independent counsel to represent its interests in the Nelson matter. The second actually is more recent, and they have independent counsel for Act 14. So up to a certain point, the Department of the Attorney General actually was representing the department until we realized we might actually be coming into direct conflict with the Department of Land and Natural Resources. And at that point, independent counsel was asked for and received. So to answer your question, the truth is that the mechanism has worked up to this point the way that it's set up, without the need for DHHL to get it on its own or have a whole lot of resistance to it.
Got it. Despite the Attorney General's testimony, would it be better to have in-house counsel that understands the ins and outs of the department and foresees these conflicts, further in advance?
It might be, except that the answer is that as a principal agency of the state of Hawaii, all agencies are represented by the Department of the Attorney General.
However, we understand that you also have to uphold the trust, and you have conflicts with federal law. There's a whole lot of stuff happening, and then prospective changes to federal law in the future. What is the cost to the state when you have to get independent counsel for these things?
Well, I don't know a number. I really can't venture to guess. I don't have that information. I can provide that to you. But the cost is actually to the department, not to the state at large. So that's actually what happened. We pay for it, I believe, through sources other than the general fund. So my understanding, and I might be wrong, so we can get back to you on that, but I do believe we pay for independent counsel. It might actually be through general funds, but somehow it's taking away, right, from, we do budget for litigation costs, but it's borne by the department, not the state of Hawaii.
So being borne by the department, of course, it takes away from your other duties. Okay, thank you, Chair.
Thank you very much. Any other questions, members? If not, thank you very much for your testimony. Let's move on. Senate Bill 1609, relating to Native Hawaiian affairs, appropriates funds for certain departments to provide grants to tax-exempt nonprofit organizations that have experience and expertise in supporting and advancing Native Hawaiian communities. And it amends Act 195, Session Laws of Hawaii 2022, to include additional grant requirements. First up, we have testimony from the Attorney General with comments. Welcome. Floor is yours. Please proceed.
Thank you. Good afternoon, Chair, Vice Chair, members of the committee. Deputy Attorney General Eli Same-Mia, appearing on behalf of the Department of the Attorney General. We just wanted to note, thank you for the opportunity to provide comments. We just wanted to note that the appropriations in Act 195 will lapse on June 30th, 2023. So we have provided some additional language to amend the bill to extend the appropriations contained in Act 195. I'm available for any questions if you have any. Thank you.
Thank you very much. Next, we have testimony with comments from the Department of Budget and Finance. Next, testimony and support from the Department of Land and Natural Resources.
Aloha, Chair, Vice Chair, members of the committee. I'm Alan Downer. I'm the Administrator of the State Historic Preservation Division. The department stands on its written testimony and support. Pardon me. Our testimony is restricted strictly to Section 2, which provides grants for national and international repatriation. The Native American Graves Protection and Repatriation Act covers repatriation of Native Hawaiian remains from within the United States. There are grant funds provided by Congress, but it is a very small amount, and Native Hawaiian organizations would be competing with all Indian tribes and Alaska villages for it. In any case, there's not enough money there. So even though the act was passed decades ago, only a tiny fraction of the collections that are in the United States have been repatriated. So we think it is appropriate to fund this activity here, even though there is a federal law. There is no comparable law internationally, and so going to foreign museums is strictly a matter that would have to be funded either by an organization itself or by the state. Happy to answer any questions.
Thank you very much. Next, we have testimony with comments from the Office of Hawaiian Affairs. And testimony and support from the Maui Office of the Mayor, Richard Bisson. Testimony and support from Sterling Wong, Council for Native Hawaiian Advancement. Please proceed, Mr. Wong.
Aloha, Chair, Vice Chair, members of the committee, Sterling Wong for CNHA. We'll stand on our written testimony in support. I would note this is a companion to HB 1508, which when this bill went through the House, I think in response to the AG's concerns, the committee had changed the language from the grants process to the procurement process, and we would support that language, making this this funding use the procurement process. Mahalo for the opportunity to provide testimony, available for questions. Mahalo.
Mahalo. Next, we have testimony and support from the Kapolei Chamber of Commerce, Kieran Polk.
Aloha, Chair, Vice Chair, members of the committee. Kieran Polk, Kapolei Chamber of Commerce. We stand in support of our written testimony that we submitted, and specifically addressing the funding for the Entrepreneur Center. Let me know if you have any questions. Mahalo.
Thank you. And just for people who are watching that haven't read the testimony, you note the West Oahu Innovation and Entrepreneur Center is a partnership between the Council for Native Hawaiian Advancement and the Kapolei Chamber of Commerce to create a co-working space and innovation center. Is that correct?
Yes, that is correct.
Great, thank you. I just want to make sure people understood your interest in this.
Mahalo.
Mahalo. Next, we have testimony in opposition from Dr. Kenneth Conklin, Center for Hawaiian Sovereignty Studies. Testimony in support from 3 individuals, Leimomi Khan, Kendrick Farm, and Dana Keave. Is there anyone else wishing to testify on Senate Bill 1609? Yes, please, come on up, introduce yourself. The floor is yours.
Aloha, Chair, Vice Chair, and members of the committee. Mark Ritchie for DBED. Our apologies, we had a glitch in getting our testimony in, so our apologies for that. But the one main point in that testimony is that we do prefer the House bill, the companion bill, solely for the fact that it uses the word appropriates funds rather than uses the word grants. And the House bill, that allows to use the RFP procurement method. That'll be much easier for us to work with that, since there is some sort of gray area when we use the word grants that I know BNF and the Attorney General have pointed out.
Thank you very much.
Answer any questions.
Thank you very much. Appreciate you being here. Anyone else wishing to testify on this measure? If not, questions, members? Seeing none, thank you very much to the testifiers. We'll go on. Senate Bill 917, proposing an amendment to the Hawaii State Constitution regarding the freedom of speech. This measure proposes an amendment to the Hawaii State Constitution to provide that freedom of speech protected under the Hawaii State Constitution does not include the expenditure of money to influence elections. First up, we have testimony and support from Michael Goliuk, Stonewall Caucus of the Democratic Party of Hawaii. Please proceed. Please proceed.
Well, thank you, Chair. First off, happy Pi Day. My name is Michael Goliuk Jr. I'm Chair of the Stonewall Caucus of the Democratic Party of Hawaii. We stand in strong support of this measure. We hopefully will pass it out so that people can vote to strengthen our election process. Mahalo for the time to this opportunity to testify.
Mahalo. Next, we have testimony from Mike Goliuk Sr. And testimony in opposition from Victor Ramos. Testimony in support from Andrew Crossland. Testimony in opposition from Gerard Silva. Testimony in support from Will Karen. And testimony in support from Dana Keave. Is there anyone else wishing to testify in Senate Bill 917? If not, questions, members? Seeing none, I think we'll move on. Senate Bill 485, relating to judges for the District Court of the First Circuit. This bill establishes one additional district court judgeship in the First Circuit. First up, we have testimony in support from the judiciary. Michelle Acosta, please proceed.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Michelle Acosta, and the Deputy Chief Court Administrator for the First Circuit. I stand on our written testimony in strong support of this measure, and I'm available for any questions the committee may have. Thank you.
Thank you very much. If I could ask you, since everyone wants to understand why you need this, could you summarize briefly why you need an additional district court judge?
Sure. Thank you, Chair. The First Circuit District Court has not had an additional judge for over 30 years, despite the population growth in the city and county of Honolulu, which is the First Circuit of the judiciary. Currently, we have 16 courtrooms that are active. We only have 14 district court judges. Of the 14 district court judges, one judge is on assignment as a duty judge and takes them away from the courtroom assignments. And also we have one of those 14 judges as an administrative judge that also takes them away from the courtroom assignments. Therefore, we have a limited number of district court judges to fully cover all of the 16 courtrooms that we have. We also do not have for our rural courts, which is in Kaneohe, Wahiawa, Ewa, and Waianae, with the exception of Honolulu District Court, those rural courts do not hold court 5 days a week due to the limited number of judges. So in order to effectively serve all the communities in the First Circuit, we request that an additional judge be approved by the legislature.
Thank you for that additional information. That's helpful. Okay, next we have testimony in support from the Department of the Prosecuting Attorney, City and County of Honolulu. And next we have testimony in support from the Hawaii State Bar Association. And also testimony in support from the Hawaii State Bar Association Collection Law Section, Jane Sugamura. Is there anyone else here wishing to testify in Senate Bill 485? If not, questions, members? Representative Ganadin, please proceed.
Administrator Acosta. Hey, good afternoon.
Good afternoon.
Where is the need most pressing in the First Circuit here on Oahu?
The need is actually to have the judge be added to our pool of district court judges to give us the flexibility to add calendars in various divisions. So, for example, currently our busy calendars are in Eva District Court, and so if we could have the judge be available to open up a calendar there, that would be helpful. But in situations, for example, like the pandemic, where we were expecting a wave of cases for summary possession cases, eviction cases, we would be able to mobilize an additional judge to open up calendars to take on those cases. So right now we have the most critical area is not necessarily one specific division, but the criticality is that we are not able to open up as many calendars as we have courtrooms because we don't have the number of judges that require that.
Okay, one more. Just a follow-up. If this bill doesn't pass, is it possible to amend the annual budget to the judiciary to allow for increased staffing?
For the judiciary's budget, there is a request for increased staffing, but we do need the authorization to increase a judge position, which is what this measure would do. But of course, we would welcome additional funding for the judiciary to increase the number of funded positions for the judiciary.
I'm only asking because a judge comes with a clerk, usually 2 or 3 staff positions, and somebody else usually it's a 5-person job sometimes. So thank you so much.
Thank you very much. Any other questions, members? If not, thanks very much to the testifier. Next, let's move on to the next measure. Senate Bill 1074, proposing amendments to the Constitution of the State of Hawaii to amend the manner in which justices and judges are appointed, consented to, and retained. It changes from 30 to 45 days, certain time periods for the appointment and consent to a justice or judge, and it harmonizes the Senate consent procedures for district court judgeship nominees to mirror the Senate consent procedures for Supreme Court justices and Intermediate Court of Appeals and Circuit Court judges. Is there anyone here wishing to testify on this measure, Senate Bill 1074? If not, there is no testimony on this measure. I will move on now to the next measure. Senate Bill 1295, proposing amendments to Article 7, Sections 12 and 13 of the Hawaii Constitution to expressly provide that the legislature may authorize the counties to issue tax increment bonds and to exclude tax increment bonds from determinations of the funded debt of the counties. So that's what it does. The title is a full description of what it does. So I'll leave it at that. Senate Bill 1295. First up, we have testimony with comments from the Attorney General. You've been so patient. Thank you, sir. The floor is yours. Please proceed.
Good afternoon. Deputy Attorney General Randall Nishiyama for the Department of the Attorney General. We recommend replacing the current reference to tax increment bonds on page 15, lines 1 through 10, because that term is already defined on page 4, line 14, and on page 5, line 2. It just simplifies the definition of tax increment bonds for purposes of the question. Thank you, and I'm available for any questions that you may have.
Thank you very much. Next, we have testimony and support from the Department of Business, Economic Development, and Tourism. Next, we have testimony and support from the Department of Transportation. And testimony and support from Hawaii Community Development Authority. Welcome. The floor is yours. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama. Craig Nakamoto, Executive Director of the Hawaii Community Development Authority. I speak in support of this measure. Tax increment financing could be a very important financing tool for the development of infrastructure. Tax increment financing is kind of based on the notion that the development sort of pays for itself, and I think it could become a useful tool in the future. Thank you.
Thank you very much. Next, we have testimony and support from the Office of Planning and Sustainable Development.
Thank you, Chair Tarnas. Harrison Rue, DoD Program Manager for the Office of Planning and Sustainable Development. We stand on our strong testimony of support. This is an administration bill. We're in concurrence with the amendments made so far, and we do also agree with the Attorney General's opinion about those changes. Thank you.
Okay, thanks very much. Next, we have testimony of comments from the Tax Foundation of Hawaii. Please proceed.
Good afternoon, Chair Tarnas and members of the committee. Jade McMillan on behalf of the Tax Foundation of Hawaii. We will just stand on our written comments. Thank you.
Thank you very much. Just looking at your testimony to see if you want to highlight anything in here. Your last paragraph, you want to mention that because that's probably one of the big points of your testimony.
Yes, Chair. So our comments on the testimony, our comments on the measure include noting that if development does not deliver as anticipated, then the government, or rather the state taxpayers, will still be liable to repay the bonds.
Okay, thank you very much. Appreciate that insight.
Thank you.
And next we have testimony with comments from the Grassroots Institute of Hawaii. Is there anyone else here wishing to testify on Senate Bill 1295? If not, questions, members? Seeing none, thank you very much to the testifiers. We'll move on to our final bill on our agenda, Senate Bill 911, relating to jurors. Clarifies that a prospective juror is disqualified to serve as a juror if they have been convicted of a felony and have not been finally discharged, in addition to not being pardoned. First up, we have testimony with comments from the judiciary. And next, we have testimony and support from the Office of the Public Defender. Thank you for your patience, sir. The floor is yours. Please proceed.
Thank you. Good afternoon. Chair Tarnas, Vice Chair Takayama, members of the committee. My name is Lee Hayakawa. I'm the Chief Deputy of the Office of the Public Defender. The Office of the Public Defender strongly supports SB 911 SD1. Excluding felons from jury service is of concern to the Office of the Public Defender because of the disproportionate impact on certain segments of Hawaii's population, specifically Hawaiians and Pacific Islanders, and disenfranchising certain people of color. SB 911 SD1 will assist in ensuring that the juries reflect the same rich diversity that is present in the multicultural communities in Hawaii. Thank you for the opportunity.
Thank you very much. Next, we have testimony in support from Community Alliance on Prisons. Ms. Kat Brady, welcome. The floor is yours. Please proceed.
Mahalo, Chair Tornes, Vice Chair Takayama, and members of the committee. Kat Brady testifying in strong support of this. You know, a vibrant democracy really depends on a jury of their peers, and it's really important that we diversify jury. I know that it's difficult for the judiciary to find jurors, so it's really important that we expand the jury pool. Participation in jury duty is really a great way for people to reintegrate back into the community, to understand what their civic responsibilities are. So we think that having people who have lived experience in the system could be very helpful to the jury pool. I included a lot of research in here that shows you what other jurisdictions are doing, and we think it's really important that we create good neighbors in our system who actually want to participate in jury duty. So we strongly support this measure. Thank you.
Thank you very much. Appreciate that testimony and the additional research that went into it. That's all the testimony we've received on this measure. Is there anyone else here wishing to testify in Senate Bill 911? If not, questions, members? Yes, Vice Chair Takayama.
Question for Mr. Hayakawa. Just so I understand, if this bill passes, a convicted felon could serve on a jury if he or she is no longer incarcerated, but could still be on parole.
No, actually, I believe that, so I should state that the Office of the Public Defender does not object to the definition of finally discharged. But finally discharged would mean that you were done completely with parole also.
Parole, okay.
But I think finally discharged adds the restitution, so that would be civil freestanding orders of restitution would keep a convicted felon who was otherwise finally discharged from serving on a jury.
Because as I understand it, a convicted felon could vote as long as he's no longer incarcerated.
That's correct.
Correct?
Yes.
Okay, so this is slightly different.
I think so, yes.
Okay, thank you.
Thank
Chair.
you. Other questions, members? If not, I have a question for you, Mr. Hayakawa. The judiciary testimony suggested that we could make an additional amendment to further clarify the definition of finally discharged. And I'll read it to you. For purposes of this section, finally discharged means the person has received or is eligible for a certificate of discharge pursuant to section 831-5. What do you think of that?
We'd have no objection to that as well.
Okay. And they also request that the measure takes effect on January 1st, 2024 to allow the courts to update the jury questionnaire. That's reasonable, right?
That is.
Okay, great. Thank you very much.
Thank you, Chair.
Any other questions, members? If not, thank you very much to all the testifiers. That's the last measure on our hearing agenda. So I'd like to welcome all of our members here and thank them for their attendance, and I'd like to move back up to the top of the agenda for decision making. Okay, first up, for Senate Bill 16, I recommend that we pass this out as House Draft 1 and incorporate the amendments that recommended by the Attorney General in their testimony. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 16 with amendments, Chair and Vice Chair vote aye. Representative Ganadin? Aye. Representative Holt?
Aye.
Representative Hashimoto?
Aye.
Representative Ichiyama?
Aye.
Representative Ilagan?
Aye.
Representative Kong?
Aye.
Representative Mizuno?
Aye.
Representative Souza?
Aye.
Chair, your recommendation is adopted.
Thank you very much. Next, Senate Bill 57. My recommendation is to pass this out with some technical amendments. And I'd like to put into the Standing Committee report their funding request, which is $200,000 per year for the next 2 years. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 57 SD2 with amendments, noting the presence of all members. Anyone wishing to vote WR or no? Seeing none, your recommendation is adopted.
Thank you. Next, we have Senate Bill 261. I will follow the recommendation of the Department of Hawaiian Homelands on this one, who had requested that we defer the measure because they already provide this information on a monthly basis, and it can be accessed via the website on the consent agenda. And so this measure is not necessary. So my recommendation is to defer Senate Bill 261. Moving on. Senate Bill 490. I am glad to hear that Hawaii County and Department of Hawaiian Homelands has a memorandum of understanding that has, I hope, raised the level of awareness of the County Police Department of their responsibility and their jurisdiction to provide services on Hawaiian homelands. My recommendation to the committee is that we defer this measure and encourage Department of Hawaiian Homelands to negotiate memorandum of understanding with the other counties as well, and pursue this through that measure, through that means, as opposed to through this measure. If after attempting to do that over the next year and you find that it's not possible and it doesn't work, then I would encourage you to come back and ask for the legislature to take action to meet this unmet need. But since you already have one MOU with one county, I would encourage you to try to establish MOUs with the other counties. So that's my recommendation, to defer Senate Bill 490. Okay, moving on. Senate Bill 738. On this measure, I would recommend moving out a House Draft 1. I want to make some amendments to this. We need to make some amendments to make it clear whether the beneficiary passed away while on the waiting list needs to be 60 years or older or terminally ill at the time of passing. We can make that clear. I want to define terminally ill as having a disease that cannot be cured and will cause death. I'd like to provide DHHL with 2 years to effectuate the act. We'll keep the defective effective date, so I'll put that language into the standing committee report. And I'll also put in the standing committee report that if necessary, that this may require consultation and approval through the Department of Interior, just to cover our bases. So that's my recommendation on this measure for House Draft 1. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 738 SD2 with amendments. All members being present, any reservations or noes? Seeing none, your recommendation is adopted.
Thank you. Next on Senate Bill 739. On this measure, I'd like to adopt the recommended amendments from the public defender, which is basically to say intentionally or knowingly in those places in the measure that currently lists intentionally, we would add the words or knowingly. That's my recommendation for House Draft 1. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 739 with amendments. All members present, any reservations or noes? Chair, your recommendation is adopted.
Thank you. Next, Senate Bill 741. I will follow the recommendation of the Department of Hawaiian Homelands, who requests that this measure be deferred in order to allow the Hawaiian Homes Commission the opportunity to consider this issue before any legislative action. I'll note for the members that the Hawaiian Homes Commission discussed this issue at their February 2023 meeting and intends to establish a permitted interaction group to further investigate this issue independent of this legislation. I think we should give the Hawaiian Homes Commission time to do this and determine how significant this issue is, how it should be addressed, and whether they can do it through rules or if they require legislation. If so, then we can see them next year on that one. So my recommendation is to defer Senate Bill 741. Next, Senate Bill 1014, relating to independent legal counsel. On this measure, I would, after hearing testimony both from the Attorney General and from the Department of Hawaiian Homelands, that it sounds like the current method works, where if the Department of Hawaiian Homelands needs to employ a private attorney, there is a process, a waiver request to the Attorney General to determine the circumstances exist whereby representation by private attorneys is appropriate. And in such circumstances, an agency may retain or employ its own attorney. And that has, in fact, been exercised by the Department of Hawaiian Homelands in the past without incident, and from our understanding, successfully so. So notwithstanding the department's wishes to move this forward, it sounds like the existing system works, and so my recommendation is to defer Senate Bill 1014. Moving on. Senate Bill 1609. We passed out the companion measure. My recommendation is to replace the contents of this measure with the measure that we passed out, which was House Bill 1508, House Draft 1, and put that language into this as a House Draft 1. Questions or concerns, members? Yeah, thank you. I'm reminded that the Attorney General also suggested an amendment regarding the lapsing of the funds in 195. So I'd like to also add to our language from HB 1508 HD1 the amendment from the Attorney General. That way we address the issue of the lapsing of funds in Act 195. Not needed? No. Oh, it's not needed for the House draft, it was for the Senate draft. Yeah. Got it. Okay, let me start over again. I'm just gonna put in House Bill 1508 HD1 into this measure and move it out. Thanks for that explanation. Appreciate the coaching. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 1609 SD2 with amendments. All members present, any reservations or noes? Seeing none, your recommendation is adopted.
Thank you. That's called real-time legal counsel. I appreciate that. Thank you. Okay, next, Senate Bill 917. On this measure, my recommendation is to pass this out as an HD1. And what I'd like to do is to take the recommendation from the Standing Committee report on this measure, Standing Committee report number 761, when it came out of the Senate, where they recommended that future committees further amend the measure by limiting the constitutional ratification question to a description of the text of the proposed constitutional amendment. Rather than, if you look at the bill, it includes some editorial comments about if the Supreme Court takes a certain action. And so it would basically simplify and make clear the actual question that would be placed on the ballot. I would also like to make, in addition to that, oh, we already have a defective date, so that's my recommendation. HD1 that further simplifies the constitutional question as I just described. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 917 SD3 with amendments. All members present, any reservations or noes? Your recommendation is adopted.
Thank you very much. Next bill, Senate Bill 485. Members, if you remember in the budget, we did recommend approval of the additional funding for one additional district court judgeship in the First Circuit. But as was described today, we also need to pass a statutory change to authorize this additional district court judgeship in the First Circuit, and that's what this measure does. So my recommendation is to pass this out as is. It already has a defective date, and move this along to finance. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 485 SD1 passing as is. Any reservations or noes? Seeing none, your recommendation is adopted.
Thank you very much. Next, moving on to Senate Bill 1074. We received no testimony on this, but I went back and reviewed the testimony on the previous versions of this measure. From our analysis, the Judiciary Committee in the Senate addressed all of the concerns that were brought up by the previous testimony from the judiciary and others. And considering that none of them testified on the measure before us today, I can assume that they're comfortable with the current language. I would like to make it clear, again, this is trying to follow up on the Supreme Court's admonition to the legislature to make the statements that are constitutional amendments that go on the ballot very clear and easily understandable. I would like to make some changes to the language of the question so that it is clear and understandable, and specifically lays out the specifics of the question so that it can be understood by a layperson, someone who's not an attorney, sort of like me, so that they would be able to vote on it with a good understanding. So basically it would say, the main parts of it actually lays out, which would require a district court appointee to be automatically considered appointed if the Senate fails to reject the appointment within 45 days of receiving the appointment notice. The Chief Justice to make another appointment from the list of district court nominees within 10 days if the Senate rejects an appointment, and the appointment and consent procedure to be followed until a valid appointment is made, or failing this, the Judicial Selection Commission to make the appointment from the list of nominees without Senate consent. It basically lays out the rest of the story so that people know what they're voting on. And then I'd like to make some technical amendments as well. That's my recommendation for an HD1. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 1074 SD2 with amendments. Any reservations or noes? Seeing none, your recommendations adopted.
Thank you. Next bill, Senate Bill 1295. I'd like to recommend amendments, HD1. I think it's could be considered technical amendments, but I want to, again, modify the constitutional question so it's very clear, saying expressly provide that the legislature may, by general law, authorize political subdivisions such as the counties to issue tax increment bonds which are payable from and secured solely by the amount of real property taxes levied and collected by a political subdivision, et cetera. The rest of the language is the same as in the bill. So it's just making it clear exactly what we're saying here so that people who are voting on it understand. In addition, I would like to include in here the recommendation from the Attorney General in their testimony so it's not repetitious in terms of the definition of tax increment bonds. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 1295 SD2 with amendments. Any reservations or noes? Seeing none, your recommendations adopted.
Thank you very much. Final bill, Senate Bill 911. I would recommend we pass out an HD1 with the amendments recommended by the by the judiciary, which further defines the words finally discharged. And I would like to make it effective January 1st, 2024. Oh, it already is, so we don't need to modify that. So it's just to add the further definition of finally discharged. Questions or concerns, members? If not, Vice Chair for the vote. Oh, wait, no, Representative Ganadin.
Oh, just to say that the federal and state constitution allow us to be tried by a jury of our peers. So who better than those who've already been through the system? Also noting, although it wasn't in the testimony, that the criminal justice system disproportionately affects certain races and cultures in our community, and those individuals deserve juries of their peers.
Absolutely, I agree. Thank you for that insight. Any other questions or concerns? If not, Vice Chair for the vote.
Voting on Senate Bill 911 SD1 with amendments. Any reservations or noes? Seeing none, Chair, your recommendations adopted.
Thank you very much, and thank you everyone for testifying today. Members, we do have hearings this week, Wednesday, Thursday, and Friday. They don't give us as many hearing dates and we had to hear all the Senate bills, so we're going to be working hard. Thank you everyone for being here. There's no further business before this meeting, before this committee. We are adjourned.